Hello friends, in the series on the income tax cases, today we will discuss an issue of the TDS where the payment has been made to the commission agents who are non-residents and those agents belong to the countries with whom there is double taxation avoidance agreement. This commission is paid outside India for securing various orders which are executed outside India. So the question arises whether in this case the liability to deduct TDS will be there, and if the TDS is not deducted, whether the disallowance at the rate of 100% under section 40 clause A clause I will be justified or not. This issue has been taken by the Honorable ITAT Mumbai bench C in the case of Deputy Commissioner of Income Tax versus Creations by Shanagar, and this case has been reported in 111 ITR Tribunal short note 7. The date of the judgment is 29th February 2024. The facts of the case are like this. In the present case, the assessee is a manufacturer and exporter of embroidered fabrics and allied products. The assessee, for securing the orders, has engaged 4 agents outside India, and these agents are from various countries like Italy, France, Greece, Lebanon, with whom the India has double taxation avoidance agreement. The terms of the payment of the commission was like this, that this commission will be paid on the FOB basis, that is free freight on board basis, and this payment of commission will be made when the assessee will receive the payment from the parties to whom the export has been made, meaning thereby that the commission is subject to the condition that the commission will be paid after the assessee has received the payments from the various clients to whom the commission agents has introduced them. The payment of 1.61 crore was made to these 4 agents. When the assessment proceedings were going on, the learned assessing officer was of the view that the assessee should have deducted the TDS on this commission payment, and since this payment has been made to the non-residents, so there is 100% disallowance under section 40 clause A clause I. Although the assessee brought this thing to the notice of the learned assessing officer that this issue is already covered by the judgment of the tribunal in the case of the assessee, where the tribunal has held that the TDS liability is not there and there is no justification for the disallowance under section 40 clause A clause I. But the learned assessing officer, by disrespecting the judgment of the tribunal, go ahead with the addition. When the assessee was before the CIT appeal gave due consideration to the order of the tribunal and deleted the disallowance made by the learned assessing officer by saying that in the present case this matter is squarely covered by the judgment of the tribunal in the case of the assessee. The revenue, as usual, without going into the merits of the case, whether this is a fit case for going into the litigation or not, moved to the tribunal, and the tribunal said that in the present case, since this matter is squarely covered by the judgment of the tribunal in the assessee's own case and on the basis of stare decisis concept says that when there is no change in the facts, then the principle of precedent should be followed, and if the revenue is not able to brought on record any fact which shows that there is any change in the facts of the circumstances of the assessee, then in that case the principle of stare decisis should not be violated. The tribunal said that in the present case the commission has been paid outside India and all the commission agents did not have any geographical or permanent establishment in India, and since the payment is made outside India and for procuring the orders which are executed outside India, there is no liability to deduct TDS in the present case on commission paid, and hence the disallowance made by the learned assessing officer under section 40 clause A clause I is not justified. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Creations by Shanagar, and this case has been reported in 111 ITR Tribunal, short notes, page number 7. The matter has been decided by Mumbai ITAT bench and the date of the judgment is 29th February 2024. Thank you, friends.